Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to discuss the January 6th, 2025 return of Kilmar Abrego Garcia to the United States from El Salvador nearly 2 months after the U.S. Supreme Court, a co-equal branch of government, in a 9-0 ruling, ordered the Trump administration to facilitate Mr. Garcia's return to the United States on April 10th, 2025. To recap, the U.S. District Court for the District of Maryland ordered the Trump administration to facilitate Mr. Garcia's return to the United States after the Trump administration admitted it mistakenly removed Mr. Garcia to his native El Salvador, notwithstanding a 2019 immigration court order which forbid the government from deporting Mr. Garcia, notwithstanding the fact that he had illegally entered the United States. In 2019, the immigration court reviewed evidence and found that Mr. Garcia had a credible fear of gang violence in El Salvador that was directed at a family food business. Therefore, pursuant to U.S. immigration law, specifically Section 8 United States Code 1231, a statute enacted by Congress, a co-equal branch of government, the Trump administration is precluded from removing Mr. Garcia without a modification of the 2019 order by a court in accordance with U.S. law. Further, the U.S. District Court for the District of Maryland also found that Mr. Garcia's removal from the United States violated Mr. Garcia's Fifth Amendment procedural due process rights. The Fifth Amendment of the U.S. Constitution states, quote, "No person shall be deprived of life, liberty, or property without due process of law." The District Court found that the Trump administration violated Mr. Garcia's Fifth Amendment due process rights when he was apprehended by ICE officers in Maryland on March 12, 2025, and removed to El Salvador only 3 days later on March 15, 2025. Mr. Garcia's removal occurred before he could retain counsel and challenge the government's allegations of Mr. Garcia's alleged MS-13 gang affiliation/membership and the government's alleged legal authority to remove Mr. Garcia from the United States, despite the 2019 immigration court order that forbids his removal without proper modification or retraction of the order pursuant to U.S. law. Procedural due process under the Fifth Amendment of the U.S. Constitution requires the federal government to provide individuals subject to removal with adequate written notice of the government's intention to remove them and the reason for the government's intended removal. Further, the Fifth Amendment Procedural Due Process Clause requires the government to provide individuals subject to removal with adequate time to retain counsel and have their day in court before the government may remove them in accordance with court orders. The late Justice Antonin Scalia, a stalwart of conservative judicial philosophy and originalism, penned the U.S. Supreme Court's ruling in a case named Reno versus Flores in 1993, stating in part, quote, "It is well established that the Fifth Amendment entitles aliens to due process of law. Procedural due process exists to prevent mistaken or knowingly wrongful and illegal takings by the government without courts of law first hearing from individuals who are subject to takings before any final taking is authorized." In this case, the District Court issued its order compelling the government to facilitate the return of Mr. Garcia so that he could be afforded all requisite rights and protections under the Fifth Amendment of the U.S. Constitution, under U.S. law, prior to the potential issuance of a final order permitting Mr. Garcia's removal from the United States pursuant to U.S. law. While Article 2 of the U.S. Constitution delegates the U.S. foreign diplomacy power to the executive branch, the judicial branch has equity authority under Article 3 of the U.S. Constitution to issue remedies to correct violations of constitutional rights by the executive and legislative branches. The district court issued a measured order requiring the government to facilitate Mr. Garcia's return by their diplomatic means of choice so that his removal proceedings could essentially be restarted in accordance with U.S. law and the U.S. Constitution. The Trump administration appealed the district court's order to the historically conservative Fourth Circuit Court of Appeals, where the court issued a 3-0 order upholding the order from the U.S. District Court for the District of Maryland. Conservative Judge Harvey Wilkinson of the Fourth District Court of Appeals wrote an April 17, 2025 order on the case, quote, "The government is asserting a right to stash away residents of this country in foreign prisons without the semblance of due process that is the foundation of our constitutional order. Further, it claims in essence that because it has rid itself of custody, that there is nothing that can be done. This should be shocking not only to judges, but to the intuitive sense of liberty that Americans far removed from courthouses still hold dear. The government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident in its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order, which requires the government to prove, quote, by a preponderance of the evidence, that the alien is no longer entitled to a withholding of removal. Moreover, the government has conceded that Abrego Garcia was wrongly or mistakenly deported. Why then should it not make what was wrong right? The executive possesses enormous powers to prosecute and to deport, but with powers come restraints. If today the executive claims the right to deport without due process and in disregard of court orders, what assurance will there be tomorrow that it will not deport American citizens and then disclaim responsibility to bring them home? End quote. Last week, as you likely saw, Mr. Garcia was returned to the United States nearly 2 months after the U.S. Supreme Court's order to facilitate his return. However, this only occurred after the Trump administration unsealed a grand jury criminal indictment filed on May 21st, 2025. The 2-count indictment filed in the U.S. District Court for the Middle District of Tennessee charges Mr. Garcia with 1 count of conspiracy to transport aliens under 8 United States Code, Section 1324, and unlawful transportation of undocumented aliens under the same section of the United States Code. The indictment appears to have been filed in a face-saving political move by the Trump administration. This is evidenced by the unusual allegations contained within the indictment that a criminal prosecutor would not typically allege without including additional supporting charges, as this could create issues with the federal rules of evidence later in the case. As former career federal prosecutor Glenn Kirshner of Justice Matters stated, quote, "The message sent by the Trump administration attorney Pam Bondi is, quote, I'm not bringing him back because I was ordered by the courts to bring him back. No, I'm bringing him back because I want him back because I want to prosecute him." Mr. Kirshner further stated, quote, "It feels like they built the entire 10-year conspiracy indictment around one traffic stop in Tennessee that disclosed no overt, clear evidence of criminal conduct. Paragraph 30 is the only paragraph that lays out any detailed factual allegations. Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.